Hi, this is estate planning lawyer Michael Pevney, and in this video we're going to talk about how trusts allow for contingencies. But before that, if you are interested in estate planning, please subscribe to this channel, hit the like button, and ask an estate planning question in the comments. I'm usually able to respond. So oftentimes the question is, should I get a trust or should I get a will? And in California, if you own property or you have little kids, the answer to that question is real simple. It's you should get a trust because it avoids probate, which is very costly and time consuming, and it doesn't give you a lot of control. And when it comes to contingencies, this is the part of the benefits of a trust I want to talk a little bit about, because a trust allows for contingencies and different contingency plans. Now let's say you have a will and you want to leave everything you own to your 2 kids, and you have a couple grandkids as well. So what happens if you become incapacitated, you become bedridden? Well, you're not dead, so the will does not control anything. Remember, a will only takes effect after you've passed away and can distribute your property after you've passed away. So the will says, I want my house to go to my 3 kids, but now you're incapacitated. Maybe you need to go to a nursing home and you're incapacitated. You can't make financial or medical decisions for yourself. So who's going to be in control of that house? Who's going to decide whether or not that house needs to be sold to pay for medical bills or to pay for anything else? Who's going to decide whether or not that house can be rented out? A will cannot do this. A trust can do this because as part of a trust, you always create a trustee. Now, with most of the trusts that I create, specifically a revocable living trust, you are the initial trustee. The trustee has control of everything inside of that trust and does whatever the trust says after you pass away. But a trustee can also maintain control of that property if you become incapacitated. And there are legal definitions of incapacity, and you can even put your own definition of incapacity in that trust. So if your primary physician says that you're incapacitated, or 2 other doctors say that you are incapacitated, then the trustee can take over. And if you are required, you can't live in that home anymore, and the home maybe needs to be sold to pay for medical bills or other debts, or you want to distribute that money to the kids now, the trustee can do that. The trustee can do that according to the terms of your trust as you create them. That trust is a contingency plan because it allows trustees to control that property in an incapacity situation when somebody's medically incapacitated. Another type of contingency that a trust can plan for is if one of your beneficiaries passes away before you do. So you have you have 3 kids, and you have each of those kids has a couple kids of their own. Now what happens if one of your children passes away before you do? Now in a will, we can build in plans for that, right? Your child's share that child that passed away can go to their own kids. So that your deceased child's share can go to those grandkids. But what if those grandkids are really little? Do you want them to get control of that money as soon as they turn 18? Because in a will, when you give property away, as soon as somebody's an adult, they have complete control of that property. And until they're an adult, whoever the guardian is, the guardian of that child's person, the guardian of that child's estate, is going to control them and is going to control their money. So what you can do in a situation like this is say, I split my estate between my 3 children, and should one of my children predecease me, I leave it to their children. And there's a fancy word for this in Latin called per stirpes. But you can further provide that if any of these children are under the age of 18 or under the age of 25 or under the age of 30, you can even have them wait until they're 50 to actually get full control of this money. And you can have your successor trustee, the person that takes control of this property, hold that money, hold that property in trust to only be used for the benefit of that grandchild until they turn a certain age, until they reach the age of majority. And until they reach that certain age, you can have the trust pay for things, for their health, their education, their welfare, their maintenance, and their support up until they reach a certain age where they might be responsible enough to handle that money on their own. So a trust provides for contingencies. There are almost an unlimited amount of contingencies that, if you think about, you can write into a trust. And that's one of the reasons why I prefer a trust over a will. Now, this is completely apart from the cost of probate and the amount of time that probate takes. When you write into a trust different contingencies and the fact that you can be incapacitated and the new trustee can take over, and that's something that's totally impossible with a will. If you've got any questions about this or anything else related to estate planning, you can set up a time to meet with me for free if you're a California resident by going to ocestateplanlawyer.com. Link should be in the comments. Please subscribe to this page for more estate planning information, and thanks for watching.